Joining us again, welcome back to the program, Peter Shamshiri, or known as Lawboy on Twitter, to the extent that anybody's on Twitter anymore, and the co-host of the 5-4 podcast, and If Books Could Kill.
It's my latest favorite to listen to, so I just got to plug that for everybody. Plus 5-4 as well. It's more relevant to what we're talking about today. But
so. Peter, I mentioned up front that I would ask you, just you're a lawyer. Donald Trump is looking for we just got to like clear the decks of that. Any interest?
If there's money up front, I'll do anything.
There you go. All right. Well, we'll send word. Well appreciated. All right, but in the meantime, before you head off to Miami. Let's talk about what took place on Friday. There were two decisions that came down. Both, I think, at least one was a bit of a shocker for everybody. Yeah. It was a Voting Rights Act. I don't know if there is a more prominent opponent or whose history of being against the Voting Rights Act is greater than John Roberts. I mean, this was almost like his inciting event as a lawyer in associated with our government. But why don't you take it from there? First, I guess, tell us what exactly the case was in Milligan.
Yeah, the case was a challenge under the Voting Rights Act to the districts in Alabama. There are 7 districts in Alabama, 7 congressional districts. 27% of the population is Black, and there was a single Black majority district. When, if you do the math, it should really be 2. So there was a challenge.
Out of 7. That's 1 out of 7.
Which I think 2 out of 7 ends up being 28%. So there are 27% Black voters. It makes sense that you'd expect 2 districts. So the challengers to the district bring a vote dilution case. And that gets analyzed under a framework from the 1980s. There's this case called Jingles, which has this whole sort of this really long process you work through to see whether there's been vote dilution. And going into it, I think the expectation was that John Roberts was going to lead the charge to either weaken that test or potentially find that Section 2, as it's currently interpreted, is unconstitutional because it requires in function the consideration of race. And so, I think most people were shocked when not only did he not find Section 2 unconstitutional, but he stuck with the test and sort of dutifully applied it and said that Alabama needs to create another majority Black district.
What makes Section 2 distinct in that way from the other parts of the Voting Rights Act, right? Because it's not as much about intent as,
Sure.
Roberts had argued in the past. It's about outcome.
That's right. So there were amendments to Section 2 in the early 80s that basically there's a Supreme Court case that said this is actually about intent. You have to prove discriminatory intent, which is, of course, very hard to do. Congress amends the law to say, no, you don't need to prove intent. You just need to show that it is discriminatory in practice. John Roberts was a lawyer working against those amendments, working to say that, on behalf of, I think, the Reagan administration, to say that the amendments should not pass. They did anyway. But that's why it's sort of unique, because it doesn't really matter in this case whether Alabama can prove that they were not trying to do anything racist. All that matters is the output.
What's also interesting to me, too, is that it's not like, it's one of the, just because Congress had amended the Voting Rights Act to be explicit in this instance is no protection, or at least it hasn't been in the past, for the Voting Rights Act. I mean, right? I mean, like we saw in Shelby, which was the case in 2013, where they were looking at I think it was pre-clearance. where the court between Scalia and et al. Basically said the only reason why Congress reauthorized the Voting Rights Act, I guess it would have been 5 years earlier, 6 years earlier, was because they're afraid of like being considered to be racist. And so we don't need to pay attention to that.
That's right. And I think it was Scalia at oral argument said the fact that the reauthorization of preclearance had been something like 98-0 in the Senate. He said that actually works against it. It proves that it's sort of, not really truly being considered by Congress, which I always found a bit rich, considering I think he was appointed under about the same number, 96, 98-0.
Right.
The Roberts approach to the Voting Rights Act has really not shown a lot of rhyme or reason other than generalized opposition to the Voting Rights Act, which I think is why this caught people off guard. I mean, Shelby County has almost no constitutional undergirding at all. He just didn't seem to like the preclearance regime. So the fact that he would come out here and just sort of fully embrace what is undeniably a court-created test from the 80s that this court would almost certainly never create. It was jarring. Not everyone was shocked, but I was shocked. Yeah.
And we should say that the way that they basically killed the preclearance provision was they didn't actually say you can't have a preclearance provision. In other words, that states that had a history of racial discrimination had to get permission to change their voting laws from the DOJ. It's that how you choose which those states are needs to be updated in a way that Congress is just going to have to figure out. And basically, for all intents and purposes, threw it into oblivion. So they could have theoretically done the same thing with this case, right? Is say, we don't have a problem with a provision that says you got to change it if the outcome is diluted, but you just need to calculate that in a different way.
Right. They could have punted it to Congress in different ways. They could have simply demanded race neutrality, which is what Alabama was pushing for. Alabama was basically saying, we have all these ways to go about creating districts that are race neutral. And the counter to that was, well, hold on. The whole point of the Voting Rights Act is to very specifically protect the voting rights of Black people in particular, and in the South in particular. So going in with a race neutral approach doesn't really make a ton of sense here. This is something that Ketanji Brown Jackson brought up in oral argument very effectively. Roberts has a history of embracing that sort of race neutrality as a constitutional principle. So I think that was a big fear. There was a fear that they could knock it back to Congress with the full knowledge that Congress wasn't actually going to do anything because Congress is in deadlock on every substantial issue. On the other hand, they could have just outright struck down Section 2, which you can essentially see that Clarence Thomas in his dissent would love to do.
So I'm going to ask you to go. There were two things that went on here, and one was that the first time these lines, these districts were challenged was back in 2020 in the run-up to the 2022 election, and it made it to the Supreme Court. In the shadow docket, they basically said, no, we're not going to deal with this here. Kavanaugh voted the other way. Mm-hmm. Roberts voted to against punting it, but only because he didn't think it should be on the shadow docket.
Right.
What do you think happened between then, aside from the Alabama probably having one, more Republican seat than they would have, and maybe also Georgia? And I mean, let's put that aside because I want to ask you about that. But what do you think happened? Because also, and you mentioned KBJ's discussion about the intent of the Reconstructionist amendments being specifically not race neutral, which is probably something that's never been articulated by any, because we are living in a different era of understanding of those amendments too. What do you think happened? I mean, I know this is complete speculation, but this is your job.
I love to speculate. I think that the most likely thing is that Roberts was feeling the heat institutionally, and he is an institutionalist, and he decided to moderate his vote on this issue, especially knowing that that Kavanaugh was going to come along. If you look at the first, I mean, it doesn't make much sense. If this comes to the Supreme Court on the shadow docket. Roberts joins with the liberals, ostensibly on shadow docket grounds. Kavanaugh is apparently fully okay with the potentially unconstitutional map being used in a full election cycle, and then switches the next year. The only thing I can think of that truly makes sense is that Roberts felt the heat and brought Kavanaugh along. I also think that Kavanaugh is enigmatic in a way. He really does have sort of odd beliefs about this stuff, and there are principles that were theoretically at play in 2021 when it first came to the court that aren't at play anymore. But I think that the prevailing theory that this was a case that would not have come out this way if you didn't have Dobbs, if you didn't have like the Clarence Thomas drama. I really think that Roberts goes the other way and is just trying to let a little bit of heat out of the whole thing. That's my best guess.
And you know that Kavanaugh likes beer.
That's right.
Okay.
We all know that.
Let me ask you one more question about that, and then we'll move on. How much do you think? Do you have any sense of where, not just the way that Dobbs was decided and the heat that came from that, and not just like, all the sort of, there's a tremendous amount of, I think, scrutiny on the court in terms of its ethics, which is, way overdue. And there's, rumblings of some type of reform in that manner, which, for a guy like Roberts would make him look bad, I think. Do you think that there's also anything going on with the leak of Dobbs? Because the idea that the court couldn't find out who did it, Alito subsequently saying, like, I know who did it after that, which I have no doubt, frankly, that he knows who did it, because I've been convinced from day one that it's someone he's associated with.
He said that looking in the mirror.
We know that, he did something to this effect back in at least two other instances. The Hobby Lobby, we know that he leaked. And we know in 2012 that he was complaining about Roberts in the ACA case to the Washington Post. Do you think that there is internally something going on with that? Because I'm also thinking about the case now escapes me, but where KBJ was the lone dissent, and Coney Barrett wrote the decision. This was just the other day. I can't even remember what the case was.
Yeah.
The 8-1.
Oh, Glacier. Yeah, Glacier, Northwest.
Glacier Northwest,
Do you think that this is playing, like, there's any dynamic here where the idea of, like, Roberts corralling Kavanaugh, and maybe, Sotomayor and Kagan working on Barrett, like, they're like, how much of this is just sort of fever dreams in my head?
Probably most of it, but I think that there is there's a degree to which, in the general sense, you're probably right. It's harder to be right in the specifics, but I think that it seems as though Roberts is wrestling a bit for institutional control behind the scenes. Part of this case, and I think maybe an underrated part of this case to non-lawyers especially, is that Alabama's lawyers were terrible and were really swinging for the fences and sort of bringing some extreme arguments as their primary arguments and sort of targeting the right wing of the court very directly. It's possible that someone like Roberts sees that as a challenge to his own control over the court, and it pushes him away from those arguments. I think that this all sort of plays together in Roberts' mind, if I had to guess. I don't know what the details are, and we might never know, but it feels to me like it's unquestionable that Roberts wants to have control over the institution and feels in certain regards like he's losing it.
is that because Alito and Thomas are essentially like becoming these two very emboldened players within the court? And my sense too is that maybe Kavanaugh and Roberts find some like connections as a little bit more pragmatic. I know I'm restating some of the stuff we already said, but that's just that's what I see from the outside. It's just so hard to say.
I think that's right. And I think that, they had some big wins. The right wing of the court, the far right wing of the court, we should say, had some big wins over the past couple of years, Dobbs in particular. And I think that emboldened right wing lawyers across the country to bring cases more aggressively. And so not only do you have the right wing with Alito, Thomas, and sometimes Gorsuch exercising a good amount of control, but people are pitching to them. Arguments are being designed to their sensibilities. It all. I think if you're someone like Roberts, it all starts to irritate you. Is my best guess. And in some cases, it might work because Roberts does have some pretty aggressive right-wing beliefs in many regards. But after a while, my guess is it's wearing on him. He might not feel particularly strongly about the gap between the center right and the far right on a particular issue in a way that Clarence Thomas might.
That's interesting. And because in some ways, what you're saying is he's signaling to the, Federalist Society and broader sort of legal circles,
I'm the Chief
I
Justice.
have limits. And so,
Right.
Bring me something that's not, so stark. Let's talk about the other case that happened. I mean, I don't know that this was as much as a surprise, but the implications of it were pretty huge. And this was a case, I can never tell. I can't.
Talevsky.
Yes, thank you. And in this case, dealt with the rights of third parties, essentially, to make state officials and other entities follow federal law, essentially.
Yeah, there was a state-run, Medicaid-funded nursing home in Indiana that allegedly engaged in some abusive or otherwise violative of the law conduct toward a patient, potentially in violation of the Federal Nursing Home Reform Act. And the question was whether they could be sued for that under Section 1983, which is this Reconstruction era law that creates a cause of action for lawsuits against state officials where they violate your rights. The section is very broad. It says that you can sue for the violation of any rights secured by the Constitution and laws. And Ketanji Brown Jackson writes the majority basically saying that's super broad. It applies to this case. They violated a federal law. You can sue when federal laws are violated under Section 1983 as a general principle. So it's fine. But the argument that the nursing home was making was that Section 1983 does not apply to laws passed under Congress's spending power, with the idea being that that spending clause legislation is sort of akin to a contract, meaning the idea is that in exchange for federal funds, states agree to certain conditions, in this case, compliance with certain Medicaid rules and regs. And so the idea was, this isn't exactly a federal law in the traditional sense. And if the court bought into that, Thomas and Alito buy into it, if the court bought into that, you're basically saying that this huge swath of what we consider to be federal law, Medicaid in particular, is essentially outside of the scope of one of the only laws that allows for private enforcement. So anything that regulators can't catch is fair game, with the big fear being that red states could effectively stop enforcing certain key provisions of Medicaid. For example, the requirement that low-income people be covered in a sort of disaster scenario, especially under a Republican administration in the future. So this was not as surprising, but there was a real risk, not just to Medicaid, but to spending clause legislation more broadly.
There are two things that struck me. Is one is that theory of it being a contract is bizarro. I mean, I understand why they do it, but it also seems like that would have been really quite a lift. Like that's 90% of what Congress does is basically spent.
It's deeply bizarre. Thomas tries his best. He basically says that the conditions that the government places on federal funds are meaningfully distinct from federal law, and I don't buy it. I suppose you can make the argument that it's a different type of law, but I don't see it as materially distinct from any other law. It's enforceable through the power of the federal government. Blah blah blah. He's sort of hearkening to what's called anti-commandeering principles, which is the idea that the federal government can't use its spending power to sort of to commandeer states, to make the states do what they want and sort of infringe upon their sovereignty.
We should say that was basically in terms of a principle, sort of a cousin to what they ruled in the ACA case, where they said, and people found that completely bizarre too. I mean, I remember interviewing a bunch of legal scholars as the case was, across the street from the Supreme Court. And they're like, and there's also this sleeper thing where they're saying that you can't expand the federal government cannot leverage their, they can't change their Medicaid program to expand it. And everybody was like, that's, and of course, that was the one sort of thing that the Roberts Court decided was, oh, yeah, you can't force people to expand a federal program.
Right.
And it's like an odd adjunct to that. But I also just wanted to know, too, that these two cases were both so fundamentally grounded in the decade or so following the Civil War. I mean, that the laws that we got during that time are basically the laws that we operate under in this country now.
Yeah. And I mean, interestingly, a lot of the big cases before the court this term, including, the affirmative action cases, are really about laws and amendments passed in this era, and which, in the view of the conservatives are sort of this ancillary portion of our Constitution and our law. And you can see it in the way Thomas writes about Section 1983 here. But I think in my view, in the view of the liberals on the court, that was an era that sort of restructured the relationship between people and the Constitution, people and the states.
Totally.
And, it's not something that is sort of limited to Reconstruction era law. It's something that should shape how people interact with the government today, including when it comes to Medicaid, for example. I mean,
the overwhelming majority of cases that seem to go to the Supreme Court end up dealing with amendments from that era, from the era of Reconstruction and statutes. I mean, 1983, we should say, be explicit about, was basically a fear that states were not going to abide by the new rules that you can't have slaves and the way you treat black people. I mean, that's what that was originally designed for, to make sure that they understood that they were under the watchful eye, I guess, of the federal government, or in some way.
Right.
Or there was recourse for people who were not getting the benefits of federal law. You mentioned affirmative action. Tee that up for us, because we're going to get this ruling in the next week or two, or days, or minutes.
Yeah. So there are a couple of consolidated, or no longer consolidated actually, cases about affirmative action. One is against UNC and one is against Harvard. The difference being, of course, that UNC is a public school and therefore has to abide by the Equal Protection Clause of the 14th Amendment. So the question there is whether the court is going to allow race-conscious admissions at all. something that Roberts has shown a great disdain for historically, especially in the education context. Although, the Milligan case is maybe the first time we've seen him give an implicit thumbs up to race consciousness under the Constitution at all. Is that enough to hang our hat on and say that maybe this comes out the other way? I don't know. Certainly Roberts has historically been very opposed to affirmative action as it exists in public schools. So I think at least before Milligan, everyone thought this was a slam dunk, 6-3, it's over for affirmative action in public schools, race conscious affirmative action, at least at public schools. And public schools will have to sort of rethink how they structure their admissions process. The Harvard case, a little more nuanced because Harvard is not a public school, but they are under the umbrella of Title VI because they receive federal funding. And ultimately what this means is that there is still an assessment of whether their admissions process is considering race too much, whether they are, in this case, discriminating against Asian Americans, which is the angle being brought here. They have a sort of convoluted admissions process because it's Harvard, but there are all these categories that applicants get assessed against, and then you get bonus points for different things, one of which is potentially racial diversity. Then there's, of course, whether you're the child of alum and donors and faculty, which is more important for the record. And all of that is sort of being challenged as improperly considering race and potentially even just outright discriminating against Asian Americans who have apparently been scoring notably low on one of the categories, the personal category, which relies very heavily on essays and recommendations and things like that. So there's a lot of nuance there. It's a slightly more interesting case in a way because there's many different directions the court could go with it.
All right, and we'll hear about that in the next, at least within the next 2 weeks or so, more than likely.
Yeah.
Lastly, the student debt case. And this is sort of like an ongoing, because even in the debt ceiling deal, theoretically, there was a provision that was agreed to and voted on that could theoretically implicate the case, right?
Yeah, I mean, it's very. So a lot of what's happening is there's a lot of moving parts. The biggest one I think is actually the fact that the COVID emergency has ended, per the Biden administration, at least, and that basically means that the way that this comes out strongly dictates the future for borrowers, because there are no emergency angles for extending the payment pause and potentially forgiving more debt. So I mean, this one has me anxious, even though I think I'm cautiously optimistic because as we discussed last time, I think this case for standing is just so terrible from the challengers. But let's just remind
everybody, it's the authority that they chose is under the HEROES Act. We can get to that in a moment, but let's deal with the standing issue because this is sort of the easy way out for the court to sort of say, we're not going to weigh in on this case. We reserve the right in the future to stop a president from relieving debt in this way. But just remind people about the standing.
Sure. So, the idea behind standing is that you have to be injured in some direct enough way to bring a case. And that's sort of awkward here for a lot of the folks bringing challenges to the loan forgiveness program, because it's relatively hard to make the case that you've been injured by someone else getting their loan forgiven. So you have borrowers, for example, who are literally saying, we didn't qualify for loan forgiveness, but we want it, and therefore we are injured and deserve to bring a lawsuit, which is outside of the realm of traditional standing, if I could put it lightly.
I mean, theoretically, you could sue the government because I'm not eligible for Medicaid.
Right. Or, I mean, just any federal program or maybe even any disbursement of funds.
Right.
It's very similar to what's called taxpayer standing, which is long rejected, which is, the idea that you could potentially sue just because you don't like what the government's doing with your money, with your tax money as a taxpayer. The more colorable challenge comes from Missouri. They have a state student loan authority, Mohella, which they say is injured by the forgiveness program because if the debt is canceled, some debt holders will consolidate their outstanding debt, which will reduce the loan authority's revenue, all of which is probably true. But the real problem that they have is that Mohella is a separately incorporated entity, which opted not to challenge the lawsuit. Which means that there is like a better challenger to the lawsuit that chose not to bring it, which courts will often use as a good reason to kick a case. So there's really no one that has a good claim to being injured there. That said, standing is, a relatively malleable sort of fake doctrine. So the court can do what they want to a degree.
Okay, so assuming that they accept the standing of these people, the right of these plaintiffs to sue, then the case, it depends on what, because there was some controversy at the time in which Biden did the loan forgiveness. And there was two different provisions, statutory provisions that they could have employed. One was the HEROES Act, which is what, why people are still getting compensated from 9/11. And allowed like the Secretary of Education to relieve debt under the auspices of an emergency, even if that emergency is not continuing. 9/11 ended 22 years ago. The other is just the Education Act, I think of like 1965, which allows the Secretary of Education to relieve debt. What is your opinion? And I know you went over this last time, but just briefly, your opinion on reliance of either one of those, and if that made a difference, particularly in light of the way that it was argued.
I don't think it made a difference. Certainly moving forward, there's a real difference as the emergency ends and gets farther away, the COVID emergency. All of a sudden, you're in a place where HEROES just can't apply anymore, and it's impossible to argue that it could. And you're kind of stuck with the Higher Education Act. There were people, scholars who I respect, who believe that the Higher Education Act was the better vehicle here. But the HEROES Act authorizes Biden to waive or modify any statutory or regulatory provision applicable to the student loan program in emergencies. That's broad authority. The problem with that, and what would ultimately be the problem with the Higher Education Act, is that the court has not been very respectful of broad delegations of authority to administrative agencies. They will call it a major question, analyze it under the major questions framework, which of course is sort of inspired by non-delegation concepts, the idea that Congress should not be able to delegate significant or maybe any powers to administrative agencies. I don't personally think that you can end run around the major questions doctrine analysis either way. And our experience of that analysis so far is that it is whatever the conservatives like and don't like as a policy matter.
Right.
So I'm not I think there are colorable arguments that if you are looking at the text of the law, that maybe the Higher Education Act is better in certain regards. But I'm not convinced that those differences are enough to matter.
And we should say though, the theory about it being under the HEROES Act is that Trump and Biden both had paused and created this moratorium where there was money that was lost by the government. And so if the authority worked there, why can't it work here? I think was the sort of theory. Like we're already engaging in this activity under this auspices, so we can just do this other thing under this auspices, which is more or less the same thing.
Yeah, and I think that the fact that the Trump administration had used the HEROES Act was most likely what the Biden folks were thinking, that they can make this argument that this is not a novel concept. This is not a novel interpretation of the HEROES Act, really. It's just a sort of natural extension of what even Donald Trump had done. And they could, hang their hat on that to a bit. And I think that that's a relatively effective argument. It's something that is somewhat hard. It sort of showed in oral argument that it was somewhat hard for the challengers to the law to work their way around that.
But if say now we're in the third kind of hypothetical tier here, if they accept both the standing and the argument that this was beyond the authority delegated to him in the HEROES Act, can Biden return for a second bite at the apple using that other authority, in theory at least, to cancel student debt in the same way?
I would think so. I would not. I don't have my sort of finger on the pulse from a political perspective, but from a legal perspective, there's really nothing stopping it. The question is more about political appetite and and it also sort of depends what the court does on the merits. If they say this is a major question and provide a really aggressive test, a really aggressive hurdle that Biden would need to get over for delegation in the HEROES Act context that applies perhaps in some regards to the Higher Education Act context, it might be that the court sort of stymies Biden's ability to do it with their decision. As it stands right now, at least theoretically, he could do it. It's not out of the realm of possibility.
All right, and I have two other elements that I think we should at least mention, because if people go back and do some reading on this, this will come up. One is during the American Rescue Act, or I should say within the American Rescue Act, Congress said that any student debt forgiveness between now and 2025, if I remember correctly, was not going to be subject to income tax as a service in kind or some type of like income, when loan forgiveness generally is considered that. Mm-hmm. That's one element. And the other is that in the debt ceiling negotiations, Congress voted to end the moratorium, with it by September 1st, I think it's going to be. Mm. And, not saying we are not, it's not just up to Biden's choice. We're going to insist that the moratorium ends September 1st, which is a tacit acknowledgement, if not an explicit one, that Biden had the authority to continue it. Therefore, they wanted to end it. And if Biden had the authority to do the debt moratorium, which he could have theoretically done forever, then Congress is acknowledging in two different ways that the administration has the authority to do this. What's your sense of how that will play, or do you think they'll just ignore it?
I think that they will ignore it, or simply say that Congress is, acting pragmatically. Generally speaking, it feels like something that gets a snarky footnote out of Alito or something, but nothing more. I tend to agree with you that it does show some tacit admission there, but I have seen the court handle that sort of sort of acceptance of power by implication thing very dismissively before. So that's my best guess.
I think that tax one is certainly stronger of the two. But all right. Well, I mean, I think that covers it. Is there any other case that you in particular, like, do you have like a sleeper case, or is that basically the docket?
Well, no, there are cases. I mean, I barely sleep anymore. The case I'm probably worried about the most, although another one where I'm sort of cautiously optimistic, is Brackeen about the Indian Child Welfare Act, and that is coming up. And there have been arguments that the Indian Child Welfare Act is potentially unconstitutional in some regard, which would be a sort of nightmare for tribal rights. And the reason I'm cautiously optimistic is because Gorsuch has been good on this stuff in the past, and so. You only need one more. But I am worried, and I certainly don't want to be on the record saying that there are no more cases to be concerned about. You should be worried all the time.
Done.
Yeah.
Peter Shamshiri, thank you so much for your time today. Really appreciate it. We will put a link to your Twitter handle, Lawboy. We will put a link to the 5-4 podcast, which you co-host and you are aware of. And also, we will put a link to If Books Could Kill.
Not that it needs it, obviously. I mean,
All right, maybe we'll just make it a dead link.
it jumped on the scene.
that works.
I'll leave the link off.
What was your guys' first episode that just like exploded? I mean, I haven't seen.
I think we did a Freakonomics
Freakonomics.
episode, and yeah, it got big.
It's just you don't see that a ton from a leftist podcast starting out. So congratulations.
All right, Peter,
Thank you.
thanks.
I appreciate it, folks.
Yeah.
Thanks so much for your time. Appreciate it.